Ooh, Justin Baldoni's lawyers just clapped back against Blake Lively's lies in the most respectful yet spiciest filings I've read yet.
Any trouble. They weren't being silenced. Their content wasn't being questioned. Their content wasn't being collected, except for a few on TikTok. I believe there were 6 that were subpoenaed and parts of their content were being asked for whatever reason. But again, they weren't in any trouble. They weren't even really being subpoenaed. It was a social media app that was being subpoenaed, and they were a part of it for basic information. Not one of those content creators needed to spend a penny on this situation. They didn't need to fight this subpoena. What is the point of fighting the subpoena when only your basic information is going to Blake Lively's legal team to help her litigation?
Could Blake Lively's own testimony be the smoking gun that destroys her harassment claims? Justin Baldoni's legal team just delivered the most devastating response we've seen in this Hollywood legal battle. They're not just fighting back, they're exposing what they call outright lies and manufactured narratives. Was this all carefully orchestrated PR warfare disguised as a sexual harassment case? Because what just happened in court suggests Blake Lively might be in serious legal trouble. The gloves are officially off, and Baldoni's lawyers are calling her bluff with her own words.
Right, to then, seal it. It was sealed in the public accordance with Lively's protective order and asked that the court not rule on the seal for a week so that the parties can meet and confer, and Miss Lively may file a motion for continued sealing if she so chooses. Now, this then prompted a bunch of PR, seemingly from Blake's side. Oh, look, he's shaming us. He's putting this out there. How dare they? This is this is about a media campaign. Meanwhile, it's Blake who's clearly speaking to the media and painting this as a victim of Justin's actions, which this is all just legal act.
The courtroom drama just escalated to nuclear levels. Justin Baldoni's attorneys have filed what can only be described as the most respectfully savage legal response of this entire case. They're systematically dismantling Blake Lively's claims, and they're doing it with surgical precision. Here's what just went down. Lively's legal team is in full panic mode after Baldoni's lawyers filed her sealed deposition transcript. The transcript that Lively desperately wants to keep hidden from the public. Why? Because according to Baldoni's team, her own testimony completely contradicts her harassment allegations. Kevin Fritz, representing the defendants, dropped this bombshell in his latest filing. Lively admitted under oath that she has no personal knowledge of any ongoing smear campaign, except for information that's so damaging it had to be redacted from court documents. Think about that for a second. The woman claiming to be the victim of a coordinated media attack just admitted she has zero evidence it actually exists. But here's where it gets really interesting. Fritz argues that Lively is now shifting her entire strategy. She's abandoning the harassment narrative and pivoting to defamation claims. Why would someone do that unless their original case was falling apart?
Continuing, this is the motion to strike the depo. Lively's lawyers then responded in rushing to file on the public docket for the entirety of the 292-page transcript of the day they received it, with no plausible legal reason to do so. The Wayfarer defendants and their counsel have proved Miss Lively's point. The correspondence Monday with Ezra to Judge Lyman says slamming teams Baldoni's blunt move and wanting everything permanently sealed ASAP. The transcript was filed in support of the argument that there is no basis to assert that Brian Friedman and his firm have participated in, fueled and advanced a smear campaign against Ms. Lively, such that their conduct has amounted to public relations work rather than an attorney.
The legal implications are staggering. Baldoni's team is essentially arguing that Lively filed bogus harassment claims and is now trying to weaponize the legal system itself. They're saying her real goal isn't justice. It's creating a false narrative through lawfare. Now, let's break down exactly how Fritz dismantled Lively's latest desperate move. When Lively's team filed what they called a motion to strike, Fritz didn't just respond. He exposed fundamental legal incompetence. First, Fritz pointed out that Lively's lawyers fundamentally misunderstood the rule they cited. Federal Rule 12 only allows courts to strike pleadings, things like complaints and answers. It doesn't cover exhibit attachments like deposition transcripts. In simple terms, Lively's lawyers either don't understand basic civil procedure, or they're throwing legal spaghetti at the wall hoping something sticks.
Here's what this actually is. And Fritz responded. And I'm going to read you here, and then we're going to read some of Leanne's commentary. As counsel, Wayfarer, yada, yada, yada. Motion to strike her final deposition transcript, currently under file seal. Fritz begins by correcting Lively's assert in the motion that the attached transcript was a rough draft. He says it's the final edit. In the footnote, he explains, we are unclear why Miss Lively, I don't think you guys can see that. Let me make sure I can lift this up. We are unclear, here it is, why Miss Lively refers to her deposition transcript as a rough draft, given that the document is not marked as rough, as such versions of transcripts traditionally are. So he's making it clear, this is not a draft. This means Lively's statements are true.
But Fritz didn't stop there. He did something absolutely brilliant. He cited Judge Lyman's own previous cases as authority. This is legal chess at the highest level. He's essentially telling the judge, Your Honor, you've already ruled on this exact issue before, and the law is crystal clear. The most devastating part of Fritz's response focuses on a glaring contradiction in Lively's position. She's claiming the transcript should be struck because it was filed to create fodder for their media campaign. But here's the problem. The transcript was filed under seal. The public can't see it. How exactly does a sealed document serve as media fodder? Fritz exposes the logical impossibility of Lively's argument. If she's really concerned about media manipulation, she has the power to keep the document permanently sealed. But doing so creates terrible optics for someone claiming to fight for justice. Why would a harassment victim want to hide her own testimony? This reveals something crucial about Lively's strategy.
Accurate transcripts, that's what they submitted. Let's continue. Miss Lively frames her argument as a motion to strike pursuant to Federal Rule of Civil Procedure 12.5 in the court's inherent power. However, Rule 12 does not authorize this court to strike documents other than pleadings. And then look what they do. They're quoting Lyman cases. Judge Lyman cases is what they're doing.
She wants to control the narrative on both fronts, claiming media victimization while simultaneously trying to prevent the public from seeing evidence that might contradict her claims. Fritz then addresses what might be the most explosive allegation in this entire case. Lively claimed that details from her deposition were immediately leaked to tabloid media. Fritz didn't just deny this. He systematically destroyed the accusation. He pointed out that multiple people had access to the deposition information. Lively herself, her husband, her multiple attorneys, legal staff from her law firm, administrative staff, and even the catering staff who served lunch. If there was a leak, it could have come from anyone, including Lively's own team. This is strategic brilliance.
Pleadings including only the complaint answer to cross-claims and counterclaims. They do not include exhibits submitted in connection with oppositions to motions. And then there's another Lyman case. He points out to Lively that their filed motions under strike only allow the court to strike documents that constitute pleadings. It doesn't allow to strike attachments. He then cites two of Lyman's own cases as authority on this point, which is just brilliant. When you can do that, you absolutely do that to remind the judge, you know this is what this is.
Fritz isn't just defending against the leak allegation. He's turning it into evidence of Lively's tendency to make accusations without proof. He's establishing a pattern of behavior where Lively points fingers without evidence. The timing of this legal battle reveals something even more significant. Fritz points out that Lively wasn't required to file any additional response to the court after their motion to quash was largely granted. So why did she? The answer exposes Lively's real strategy. She filed what Fritz calls a gratuitous letter to the court, additional argument disguised as a motion to strike. She was trying to get in the last word to control the narrative one more time. But this tactical mistake backfired spectacularly. By filing additional arguments, Lively gave Fritz the opening he needed to respond with evidence, including her own deposition testimony that apparently contradicts her entire case.
Further, Miss Lively does not contend to the deposition transcript contained abusive, improper, or libelous materials, which might warrant the court's exercise of its inherent power. Fritz is arguing here that Lively has not even stated that the transcript contains anything bad, nor can she, as it's her own words. Let's continue. After all, the deposition transcript records Miss Lively's own words. Miss Lively contends that the transcript must be stricken based on her speculation that it was filed for the purpose of the transcript in the public domain fodder for their media campaign. The transcript, however, was filed under seal, and Miss Lively has the option of moving to keep the document sealed, although it's puzzling why she seeks to conceal her own testimony in an action in which she is the plaintiff.
Fritz makes it clear that Lively invited this response by opening the door with her unnecessary filing. In legal terms, she walked right into a trap of her own making. Could this strategy completely backfire in court? Because fighting back against false accusations isn't retaliation, it's self-defense. Let's rewind for a second and understand how we got to this nuclear moment. This legal war began when Blake Lively filed sexual harassment allegations against Justin Baldoni during the production of It Ends With Us. She claimed there was a coordinated smear campaign designed to destroy her reputation and career. Initially, the media narrative heavily favored Lively. Major outlets ran stories portraying her as a victim of Hollywood's toxic culture. The harassment allegations seemed serious and credible on the surface. But then something changed. Baldoni's legal team began fighting back aggressively, filing counterclaims and demanding depositions. They weren't just defending, they were going on the offensive, claiming Lively's allegations were fabricated.
Very good point here. Her assertion that it should be stricken because it was only filed to serve as fodder for the untraceable smear campaign is made without any evidence, because there isn't any, and Lively has the choice to permanently seal her own testimony, although it would be bizarre for her to seal her testimony because she's made it clear she's here to testify in court, and this is her testimony under oath in a court. We continue. Let's go to page 2. He then takes a shot at Lively by stating that she was not required to file any further response to the court. He also reminds Lively that their motion to quash was largely granted, which is what this paragraph here is discussing. Fritz then argues in the blue section here that because of her gratuitous letter to the court, which was further an argument on our opposition to motion, which was disguised as a motion to strike, Lively invited Wayfair to respond with evidence in the transcript attached.
The turning point came when Fritz filed that explosive letter revealing details from Lively's deposition. Suddenly, the narrative began shifting. If Lively really was the victim of a smear campaign, why was she trying so desperately to keep her own testimony sealed? That's what brought us to this moment, a full-scale legal war where both sides are fighting for their professional lives and reputations. From a legal standpoint, what Baldoni's team just did is absolutely brilliant. They're not just responding to Lively's motion, they're systematically exposing the weaknesses in her entire case strategy. First, they're arguing that Lively fundamentally misunderstands court procedures. Her motion to strike the deposition transcript? Fritz points out that the rule she cited doesn't even apply to the documents she wants removed. In simple terms, this means Lively's lawyers either don't understand basic civil procedure, or they're making desperate arguments hoping something sticks. But here's the most devastating part. Fritz is citing Judge Lyman's own previous cases as authority. This is legal chess at its finest. He's essentially telling the judge, "Your Honor, you've already ruled on this exact issue before, and the law is clear." The strategic implications go even deeper. By pointing out that Lively could choose to permanently seal her own testimony, Fritz is calling her bluff. If her testimony really supports her harassment claims, why hide it? The optics are terrible for someone claiming to be fighting for justice. Most importantly, Fritz addresses the leak allegations head-on. When Lively claimed that details from her deposition were leaked to tabloids, Fritz didn't just deny it. He pointed out that the leak could have come from multiple sources, including Lively's own team, her husband, her attorneys, or even the catering staff. This is legal warfare at its most sophisticated level. What we're witnessing could fundamentally change how celebrity harassment cases are handled in the future. If Baldoni's team proves that Lively manufactured this controversy for PR purposes, it could set a precedent that makes it much harder for false accusers to weaponize the legal system. The broader implications are staggering. This case is exposing the intersection of Hollywood power politics, media manipulation, and legal strategy. We're seeing how modern PR campaigns can be disguised as legitimate legal actions. Fritz's filing reveals something crucial about the current media landscape. When he points out that Lively's team immediately went to the press after the deposition filing, he's exposing a pattern. This isn't about seeking justice through the courts, it's about controlling the narrative through media manipulation. But here's what makes this case so significant. Baldoni's team isn't backing down. They're not trying to settle quietly, or make this go away. They're fighting back publicly and aggressively, demanding accountability for what they claim are false accusations. This could signal a shift in how high-profile defendants handle harassment allegations. Instead of immediately apologizing and hoping for leniency, we might see more aggressive pushback against claims that lack evidence. The entertainment industry is watching this case closely because the outcome could determine whether accusations alone are enough to destroy careers, or whether due process and evidence still matter. If Lively loses this case, it could send shockwaves through Hollywood. It would prove that even with media support and public sympathy, false accusations can't survive legal scrutiny. And if this case moves forward with Baldoni's counterclaim succeeding, it could expose an entire system of manufactured controversies and strategic legal harassment that goes far beyond just these two celebrities. The real question isn't whether Blake Lively will win or lose. It's whether the truth can survive in an era of weaponized narratives and trial by media. What do you think? Is this a case of legitimate harassment allegations being defended or sophisticated PR warfare disguised as justice? Drop your take in the comments below, because this legal battle is far from over, and the implications will reshape Hollywood for years to come.
The tide is truly turning as reporters are now finally unafraid to share what they really think of Blake Lively. Also, a new legal filing that has me here defending Perez Hilton.
And she said to me, "Did you even see Age of Adeline? It doesn't just take place in the 30s. It takes place over 3 decades." And then she stomped away. And I was sort of like,
are you kidding?
I did see Age of Adeline. I actually like that movie. I watched.
The walls are closing in on Blake Lively as reporters finally break their silence about her shocking behavior behind the scenes. But that's not even the most disturbing part of this story. New legal filings reveal tactics so extreme that even veteran entertainment journalists are calling them unethical.
Record. So I was surprised to see Page 6 Radio featuring 3 of their hosts and our senior reporter, Mara Siegler, sharing feelings about Blake. Honest feelings about Blake. I want you to hear
Team
this.
Justin, but I'm firmly not Team Blake Lively.
Yeah.
I'm anti-Lively.
Okay,
You're
yes.
anti-Lively.
And I'm neutral on him, I guess.
Gotcha.
But
Okay.
definitely not her.
I feel like a lot of people feel the same way
Yeah.
that you feel in this situation. Yeah.
I've met her.
Oh,
Okay.
how was it?
Yeah, same. But I want to hear your experience.
Could this desperate legal strategy actually backfire in court? And why are Blake's own lawyers now targeting children in their documents? The answers reveal a celebrity meltdown that's spiraling completely out of control. Page 6 reporters just shattered years of silence with explosive revelations about Blake Lively's treatment of entertainment media. These aren't anonymous sources or unverified claims. These are established journalists going on record with their personal experiences, finally breaking the code of silence that has protected Blake for years.
I've never actually told this story. 'Cause I feel
tell
like
it.
a rep.
She's afraid. They're all afraid, but here she is. Okay, I guess I got to tell Sirius XM Page 6 Radio.
You're page 6 yourself.
It was when she did Cafe Society with Woody Allen.
The first bombshell comes from Page 6 senior reporter Mara Siegler, who describes a promotional event that turned into a humiliating public confrontation. Picture this scenario: a simple interview setup for Blake's film, Cafe Society. The question was pre-approved by Blake's own representatives, completely standard industry practice, asking about her connection to the 1930s time period featured in both her recent films.
Okay.
We had a television show at the time, Page 6 TV.
Yes. Yeah.
I was there with a camera. I had talked to a rep before. I really just needed her to answer one thing.
Right.
On, that's all they wanted. I had been told what question to ask her. Normally we wouldn't do that. But again, this was for television.
Yeah.
We just needed her to say.
Instead of providing a basic promotional answer that would help market her movie, Blake launched into a condescending verbal attack. She questioned whether the reporter had even watched The Age of Adeline, dismissing the question with obvious contempt. Her exact words were brutal. "Did you even see Age of Adeline? It doesn't just take place in the 30s. It takes place over 3 decades." But here's the crucial detail that makes this story so damaging. The reporter had seen the movie. She was actually a fan who had watched it twice. This wasn't ignorance. It was Blake choosing hostility over basic professional courtesy, even toward journalists who genuinely supported her work.
Just on Age of Adeline, what do you love about the decade of the 30s? Because Cafe Society happens it was the 20s or 30s. Yeah. Her rep brings her over. I ask her this pre-approved.
A question you would never care about Blake Lively's answer also. Hey, Blake! Yeah.
What do you like about the 1930s? Lively? Who cares? Just tell me anything
The
nice.
reporter's shock is palpable in her retelling. This was supposed to be easy promotional content, the kind of softball interview designed to generate positive buzz. Instead, Blake turned it into a public humiliation.
And she said to me, "Did you even see Age of Adeline? It doesn't just take place in the 30s. It takes place over 3 decades." And then she like stomped away. And I was sort of like,
Are you kidding?
I did see Age of Adeline. I actually like that movie. I watched it like twice.
Stomping away after her verbal assault as if the reporter had committed some unforgivable offense. But the pattern of contempt runs much deeper. Another Page 6 journalist reveals how Blake completely abandoned a scheduled press line for the film Savages.
At the time.
Oh my God.
And and I just found that to be very, like, listen, I'm doing a job, you're doing a job. It's your job to be on the red carpet.
Yeah.
Wow. That's so funny. I had a
Leaving an entire room of reporters waiting indefinitely. These weren't paparazzi or tabloid writers. These were legitimate entertainment journalists who had arranged their schedules and allocated resources to provide promotional coverage.
we all revolted, like, there's no way that we all came down here and Blake Lively didn't do the carpet. Oh, Savages. The movie was Savages. And that we turned into Savages. We were like, get Blake out here. So her rep, I've had great experiences with her rep.
Me too. I love the rep. I just want to say that. I do love her.
Yes.
I hope she's not mad at me.
Leslie Sloan. We're talking about Leslie Sloan?
Yeah. I hope she's not mad at me.
I'm a fan of Leslie Sloan. I honestly am.
The situation became so absurd that the press pool collectively revolted, demanding Blake's return. Think about how unprecedented this is. Professional journalists don't typically stage confrontations with celebrities. For them to unite in protest suggests Blake's behavior crossed every line of professional conduct. When Blake finally deigned to appear, the restrictions imposed were deliberately insulting. Reporters could ask only one pooled question, meaning no individual interviews, no follow-ups, no meaningful interaction.
Sloan was like, "All right, guys, like we'll bring her back." So we
look how annoyed Leslie. All right, fine. We'll do you. We'll make sure we give you what you came for, even though you all came out in your night. Fine, we'll give
brought
you.
her back, and then she was like, "But you get one question, and it has to be pooled. Pooled means that you get to do the interview with others. It's not exclusive." So we all had to think of one question, and then everyone looked at me. And at the time, I was working for.
Anyway, blah blah blah.
I just eat cupcakes all day. Sort of okay. And so
So the question was, how do you stay in shape? Was the
asked
question.
her, and she was like, "I just eat cupcakes all day." And then that was it. And it actually did get a lot of pickup. And at the time, I thought like, oh my God, that's so funny. She's so quirky. She just eats cupcakes all day. Like, I'm the one who got to ask the question. We had a moment. But then when all of the interviews resurfaced where she was rude to report, where she was not so nice to reporters, I was like looking at it through a different lens. And I was like, wait, was that just condescending? Was she dismissing me?
You know what? I feel she was actually rude to Mara.
The entire press pool had to collaborate on a single query, reducing experienced journalists to the level of amateur bloggers begging for scraps. The question they settled on reveals their desperation. How do you stay in shape? This is exactly the kind of vapid content that serious entertainment reporters typically avoid, but Blake's hostility had reduced them to asking for basic promotional material just to salvage something from their wasted time. Blake's response was equally telling. Her dismissive answer about eating cupcakes all day seemed quirky and relatable at the time, generating the kind of lighthearted coverage that publicists dream about. But viewed through the lens of her documented contempt for media professionals, the response takes on a more sinister tone. Was she mocking the question itself? Dismissing the reporter who asked it? The journalist now suspects the answer was deliberately condescending, designed to make him feel foolish for asking such a trivial question while simultaneously providing the meaningless soundbite that promotional requirements demanded. What makes these revelations particularly explosive is their source. Page 6 isn't a scandal sheet or gossip blog. It's an established entertainment outlet with professional relationships throughout Hollywood. Their reporters work closely with celebrity publicists like Leslie Sloan, Blake's own representative, maintaining the delicate balance between critical coverage and industry access. For Page 6 journalists to publicly criticize Blake suggests her behavior was so consistently problematic that it overwhelmed professional courtesy considerations. These reporters risk damaging relationships with powerful publicists who control access to major celebrities, yet they chose to speak out anyway. The timing is equally significant. These stories have been buried for years, with reporters keeping their negative experiences private to maintain professional relationships. The fact that they're now speaking publicly suggests a fundamental shift in how the entertainment industry views Blake's behavior. Why risk burning bridges with powerful Hollywood publicists now? The answer points to a pattern of behavior so consistent and egregious that staying silent became ethically impossible. When multiple journalists from the same professional outlet independently confirm similar experiences, it suggests systematic problems rather than isolated incidents. The current legal battle stems from Blake Lively's allegations against her. It ends with us, director and co-star Justin Baldoni. She claims workplace harassment and a coordinated smear campaign designed to damage her reputation. Blake's legal team filed complaints alleging that Baldoni's representatives orchestrated negative media coverage through strategic leaks and manufactured controversies. The case initially appeared to focus on professional misconduct and potential contract violations. However, the story took a dramatic turn when evidence emerged suggesting Blake's own team may have engaged in similar media manipulation tactics. Text messages and communications revealed discussions about managing public perception and controlling narrative flow. This revelation transformed the case from a straightforward harassment complaint into a complex battle over media strategy and public relations warfare. Both sides now stand accused of attempting to manipulate press coverage for strategic advantage. The involvement of high-profile entertainment journalists like Perez Hilton further complicated the situation. Blake's team suggested that negative coverage might be financially motivated, implying that opposing counsel was paying for favorable stories. These accusations created a dangerous precedent, essentially arguing that any critical entertainment reporting could be dismissed as purchased content rather than legitimate journalism. The legal implications of this case extend far beyond celebrity drama. This team is essentially arguing that entertainment journalism critical of their client represents coordinated harassment rather than protected speech. In simple terms, this approach could criminalize standard entertainment reporting. If successful, it would create a legal framework allowing celebrities to sue journalists and media outlets for negative coverage by claiming it represents organized harassment campaigns. This strategy appears legally questionable for several reasons. First, entertainment journalism has established First Amendment protections, particularly when reporting on public figures. Courts generally require proof of actual malice or deliberate falsehoods for successful defamation claims against celebrities. Second, the evidence supporting coordination claims seems circumstantial at best. Blake's team points to timing and messaging similarities as proof of conspiracy, but these patterns could easily reflect standard news cycle dynamics rather than deliberate coordination. The inclusion of children's photos in legal documents represents perhaps the most problematic tactical decision. Legal experts note that such inclusions serve no legitimate purpose in harassment or defamation cases. The tactic appears designed to intimidate rather than support legal arguments. This approach could backfire spectacularly in court. Judges typically view attempts to drag family members into celebrity disputes unfavorably, particularly when minor children are involved without clear relevance to the case. The strategy also risks triggering sanctions for frivolous litigation tactics. Courts have broad authority to penalize attorneys who file documents containing irrelevant personal information clearly intended to harass opposing parties. This case could fundamentally reshape how celebrity legal teams approach media relations disputes. If Blake's aggressive tactics succeed, expect similar lawsuits targeting entertainment journalists who publish critical coverage of high-profile figures. The implications extend beyond celebrity culture into broader press freedom concerns. Entertainment journalism, while often dismissed as gossip, serves important functions in holding powerful figures accountable for their professional conduct. Consider the pattern emerging here. Multiple journalists from different outlets sharing similar experiences with Blake's dismissive behavior. These aren't coordinated attacks. They're independent confirmations of problematic conduct patterns. The timing of these revelations is particularly significant. Reporters who previously remained silent are now speaking publicly, suggesting a shift in the entertainment journalism landscape. The traditional power dynamic between celebrities and media appears to be rebalancing. Page 6's decision to allow their reporters to share these stories represents a major shift in entertainment journalism standards. The outlet has historically protected celebrity relationships, making these public criticisms particularly noteworthy. This trend could encourage more journalists to share their experiences with difficult celebrities, potentially exposing systematic problems in how some high-profile figures treat media professionals. The legal precedent could also impact how harassment claims are evaluated in entertainment industry contexts. Courts may need to distinguish between legitimate workplace complaints and attempts to weaponize legal systems against critical media coverage. The most disturbing aspect of this case isn't the celebrity drama. It's the attempt to silence legitimate journalism through legal intimidation. Blake's team isn't just defending their client. They're attacking the fundamental principle that public figures remain subject to media scrutiny. The inclusion of family photos in legal documents crosses ethical lines that should concern everyone, regardless of their opinion about Blake Lively or Justin Baldoni. Using children as leverage in celebrity disputes represents a dangerous escalation in legal warfare tactics. What's particularly revealing is how Blake's own private communications contradict her public legal strategy. Internal texts show her team dismissing Perez Hilton as irrelevant and attention-seeking, yet they simultaneously argue he's influential enough to damage her reputation through coordinated attacks. This contradiction undermines their entire legal theory. Why would anyone pay someone they privately consider irrelevant and ineffective? The logical inconsistency suggests these harassment claims may be more strategic than substantive. The broader entertainment industry is watching this case carefully. If aggressive legal tactics succeed in silencing critical coverage, expect similar strategies to proliferate throughout Hollywood. Celebrity legal teams may conclude that intimidation works better than professional media relations. Conversely, if courts reject these tactics, it could strengthen protections for entertainment journalism and establish important precedents about the limits of celebrity legal privilege. The tide is turning in this high-stakes legal battle, but the outcome remains uncertain. What's clear is that Blake Lively's attempt to control media narrative through aggressive litigation has backfired spectacularly, encouraging more journalists to share their negative experiences publicly. The case now represents something larger than celebrity drama. It's become a test of whether powerful figures can weaponize legal systems to silence critical media coverage. The implications will extend far beyond entertainment journalism into broader questions about press freedom and accountability. And if this case moves forward with its current aggressive tactics, it could expose everything about how some celebrities really treat the media professionals who help build their careers. What do you think about these new revelations? Are Blake's legal tactics justified, or has this gone too far? Drop your take in the comments below, and let us know if you've had similar experiences with celebrity interviews that seemed unnecessarily
claims and they are panicking. Okay, so you know how Justin Baldoni filed that $400 million countersuit that has now since been dismissed? Well, overnight, Blake Lively filed a motion to compel, saying that they never fully turned over all of those documents from their countersuit that they referenced and cited and annotated and all the jazz, right? And now she wants them.
Blake Lively just made a move that has legal experts scratching their heads. After Justin Baldoni's $400 million countersuit was dismissed, most people would assume the case was over, but not Blake Lively. She is now demanding discovery from that very same dismissed case, claiming she needs to see everything Baldoni's team had planned to use against her.
They're asking for the court to remove privilege on a group text between Brian Friedman and some of the defendants. And her argument is the same that she has been kind of arguing up until this point, that he wasn't actually being a lawyer. He was being their PR person. And this is where I think things get a little brave, as they go, just because Nathan and Abel were on the group text with Brian Friedman, they're saying that this served as Wayfair's defendant media strategy and destroyed any claim of attorney-client privilege.
Could this aggressive legal strategy actually backfire? Or is this a calculated move that reveals just how desperate things have become? What we are seeing unfold right now could change everything we thought we knew about this Hollywood legal battle. Here is what happened overnight. Blake Lively filed a motion to compel discovery, essentially telling the court that even though Baldoni's countersuit was dismissed, she still wants access to all the documents, communications, and evidence his legal team had gathered. This is not your typical post-dismissal request. In fact, legal experts are calling it one of the most aggressive discovery moves they have seen in a celebrity case.
I cackled a little bit at this one. He didn't give the video of his wife giving birth. Like, he hasn't turned that over.
So the motion specifically targets several explosive areas, and each one reveals a different aspect of Lively's legal strategy. First, and perhaps most damaging, Lively is demanding access to group text messages between Brian Friedman, who served as Baldoni's attorney, and other defendants in the case. Her argument is stunning in its boldness. She claims Friedman was not actually functioning as a lawyer, but as a public relations strategist, which would strip away attorney-client privilege protections.
It honestly looks like she doesn't have what she needs, and I don't know. They're going back to a dismissed case that they're probably going to have a very hard time fighting to get. I don't know, maybe not. I need that's why I've been waiting all morning for somebody smarter than me to go over this, but nobody else is coming in. So I'm going to ask my questions, and my questions are, are they allowed to go and actually go back and say, I know your case is dismissed, but we need all the discovery from that? Like, I don't think that's, but then I don't know because all of those cases are so intermixed.
But here's where it gets legally fascinating. The group texts allegedly included Nathan Kahane and Jamie Heath, who were not just random participants. They were actively involved in the litigation as defendants, while simultaneously working on media strategy. Lively's team argues that this dual role destroyed any claim to attorney-client privilege. In simple terms, when you mix legal advice with PR strategy in the same conversation, you might lose the legal protections that normally keep those communications private.
The judge needed the whole transcript for the small portion they were quoting. No.
So now we've got Attorney McCaffrey discussing Blake trying to get the transcript of the deposition removed. They included it as an exhibit, even though it was, sealed or whatever. They included it as an exhibit to reference something they were mentioning. But again, it's very normal for that to happen.
Think about the implications here. If a judge agrees that Friedman was doing PR work instead of legal work, those private communications become fair game. Every strategy session, every discussion about how to handle Blake Lively, every piece of advice given about managing the media narrative could potentially be exposed. We could see internal discussions about how to discredit Lively, how to shape public opinion, and how to coordinate their legal and media responses. So,
Do I and other lawyers I routinely am against just file the whole deposition transcript if I'm using it as an exhibit in a motion? Yes. I think I referenced that motion for summary judgment that I was working on.
The legal precedent this could set is enormous. If successful, Lively's argument could fundamentally change how attorneys handle high-profile cases. Law firms might need to completely separate their legal teams from their PR consultants to avoid losing privilege protections. But the most bizarre demand in the entire motion involves a water birth video featuring Justin Baldoni's wife. Yes, you heard that correctly. This is the same video that Lively previously complained about being shown during the production process, claiming it made her uncomfortable and was inappropriate workplace behavior. Now she wants to examine it herself, claiming it could help jog her memory about events that occurred on set.
Lil girl attorney offering her opinion that Blake Lively has dirty tactics that she's using to come after Justin Baldoni's attorney.
Abe is trying to do is make Brian Friedman into a fact witness in this case. If he is a fact witness in this case, then discovery is relevant to support Lively's claims.
Contradiction here is striking. Lively's original complaint suggested that being shown this video was part of the hostile work environment she experienced. Now she is actively seeking access to the same material. Critics are pointing out that Baldoni had posted portions of this birth experience on his own social media, making it hardly the private, invasive content that Lively's team originally portrayed it as. Legal experts are divided on this particular demand. Some see it as Lively's team being thorough in their discovery requests. Others view it as an attempt to embarrass Baldoni by forcing him to turn over personal family moments, even those he had previously shared publicly.
So the judge will have to weigh whether or not Friedman being a potential fact witness in this case outweighs the potential risk of producing work product or privileged information.
The timing of these demands is also strategically significant. By waiting until after Baldoni dismissed his countersuit, Lively's team avoided the normal reciprocal discovery process. Under typical circumstances, if she demanded this level of access to his materials, his team could have demanded equal access to her communications and documents. But with his case dismissed, the discovery flow becomes one-directional. There is another layer to consider here. Lively's motion also demands access to sealed deposition transcripts that Baldoni's team had referenced in their now-dismissed case. She argues that because they cited these transcripts in their legal filings, they waived any confidentiality protections. This is a legal argument that could have implications far beyond this case. The legal community is split on whether this strategy will work. Some experts are calling it a desperate fishing expedition, suggesting that Lively's team does not have the evidence they need for their original case and are hoping to find it in Baldoni's materials. Others believe Lively's team has identified genuine weaknesses in how Baldoni's side handled privileged communications and are exploiting those vulnerabilities brilliantly. The most telling aspect of this entire discovery battle might be what it reveals about the confidence level of both legal teams. If Lively's case was as strong as initially presented, would her team need to take such aggressive steps to obtain additional evidence? Conversely, if Baldoni's team had nothing to hide, why dismiss the countersuit rather than proceed to discovery, where both sides would have equal access to each other's materials? Why would Blake Lively risk appearing overly aggressive with these demands? The answer might reveal just how much pressure her legal team is feeling right now. These are not the moves of a legal team that feels confident about their existing evidence. These are the moves of attorneys who believe they need additional ammunition to win their case. Let us rewind for a moment to understand how we got to this unprecedented situation. The entire legal battle stems from Blake Lively's initial complaint against Justin Baldoni, where she accused him of sexual harassment and creating a hostile work environment during the filming of It Ends With Us. Baldoni responded with that massive $400 million countersuit, claiming Lively had destroyed his reputation and career prospects through false allegations. That countersuit painted a picture of Lively as the real problem on set, someone who made unreasonable demands and created the very hostile environment she later complained about. But here is where things took an unexpected turn. Baldoni's legal team made what many now see as a critical error. They dismissed their own countersuit, likely believing it would strengthen their position in the original case. Instead, it opened the door for exactly what we are seeing now. The dismissal was supposed to simplify the legal landscape. Instead, it has created this unusual situation where Lively can argue she needs access to materials from a case that technically no longer exists. It is a legal gray area that could set important precedents for how dismissed cases are handled in the future. From a legal standpoint, what Blake Lively is attempting here walks a very fine line. In simple terms, she is arguing that even though Baldoni dismissed his case, the discovery materials he gathered are still relevant to her ongoing claims. This is not typically how the legal system works. When a case is dismissed, the general expectation is that associated discovery materials remain with the parties who gathered them. But Lively's team is making a creative argument. They claim that because all these cases are interconnected, and because some of the materials might contain evidence of attorney-client privilege violations, the normal rules should not apply. The privilege issue is particularly complex. Attorney-client privilege is one of the strongest protections in the legal system, but it can be waived if the attorney steps outside their role as legal counsel. If Brian Friedman was indeed coordinating public relations strategy while also providing legal advice, it could create what lawyers call a waiver of privilege. The inclusion of PR professionals in group communications with the attorney adds another layer of complexity. In simple terms, when lawyers include non-lawyers in confidential communications, it can destroy the privilege that would normally protect those conversations. This could be a brilliant legal strategy or a costly mistake. If the judge agrees with Lively's arguments, it could expose Baldoni's entire litigation strategy. If the judge rejects them, it could make Lively appear desperate and overreaching. The broader legal community is watching this case closely because it could establish new precedents for how mixed legal and PR strategies are handled in high-profile cases. This case is revealing something important about how celebrity legal battles are fought in the social media age. The line between legal strategy and public relations has become increasingly blurred, and courts are struggling to keep up with these new realities. If Blake Lively succeeds in her discovery demands, it could fundamentally change how attorneys approach high-profile cases.